number 5, matter of Aurora Associates versus Locatelli. Counsel?
Yes, thank you. If it pleases the court, my name is Joseph Goldsmith. I represent the appellant Aurora Associates, and I am requesting to reserve 2 minutes for reply.
2 minutes, sir? Thank
Yes.
you.
Can you hear me?
Yes, we can hear you, but just do try to maintain a higher level than ordinary of your voice.
Yes, no problem. So I am here to talk about a loft unit in Manhattan that underwent a purchase of rights of fixtures improvements pursuant to multiple dwelling law 286-6 and 286-12. The question for this court is what happens afterwards with respect to rent regulation. Right now, between...
Counsel, I have a question for you.
Yes.
So because the unit that is at issue here is registered and it's covered by the loft law, that
Correct.
makes it an interim multiple dwelling. And given that the rent stabilization law applies to housing accommodations in Class A or Class B multiple dwellings, and those are, of course, made subject to rent stabilization by the ETPA, why isn't an interim multiple, an IMD, interim multiple dwelling unit like yours, beyond the reach of the rent stabilization law?
I agree with you that it is beyond the reach of the rent stabilization law and code. There is a separate section.
Go ahead.
There's a separate section of rules and regulations under the loft law that governs this particular unit, how it is to be used and maintained, and what the rents are that may be collected and charged for this
So
particular.
do we stop there?
I would like to stop there. I believe that is the end of it, that those regulations under the loft law are what controls. As long as the owner and the tenants live and comply with the terms of the loft law, those are the rules and regulations upon which they have to.
So let me ask you about that.
Yes.
The unit was registered under the loft law in 1983,
Yes,
and as of 2016, it still had no C of O.
that is correct.
And there are rules in the loft law that have timetables that require completion of various things and obtaining a C of O within a much shorter period of time than 39 years.
Correct.
Okay, so let me ask you one other thing. Is it your understanding that under the loft law regulations promulgated by the city, the purchase under, let's say, 12, although it could be 6 and 12, doesn't matter, the purchase of the fixtures and of the rights relieved you of the loft law regulations regarding rent, but left you subject to the remainder of the loft law,
That is correct.
including your inability to evict a current tenant?
That is incorrect.
So why?
So you have the ability, once you purchase the rights and fixtures, to deregulate it pursuant to rent regulation under the loft law. But you still have the obligation to legalize the unit for residential use.
Sure, but you haven't done that, right?
Haven't done that. The loft
Okay.
board and the loft law has rules, regulations, penalties,
Right.
that they can enforce against the owner for that failure.
But doesn't the loft law contain anti-eviction protections for tenants?
For tenants whose unit has not been subject to a sale pursuant to
Where
286.
does it say that, though? Doesn't the regulation issued by the city at 210D2 say the only thing you're relieved of is the rent regulation requirements that are imposed by the loft law, and that you remain subject to all of the other requirements of 7C?
So the prohibition against evictions are for tenants that are protected under the loft law's rent regulation aspect. The other aspects of the loft law that are still in play after a purchase of rights and fixtures under 6 and 12 are with respect to the legalization of the building. The loft board has promulgated cases, and I cite, maybe 10, 15 cases in my briefs, about how after the purchase of rights and fixtures, that's a free market tenant. That's a free market unit, subject to rent increases that are agreed upon by the parties, subject to lease terms that are agreed upon by the parties, subject to eviction if the tenancy is not subsequently renewed by the parties. Because there is no form of continued occupancy right under rent regulation, and because there is no right to set increases that are tied to what the loft board's rent regulations provide, an owner and a tenant who don't come to terms on a lease renewal in a unit that's already been rent deregulated that way is subject to eviction for holdover.
But counsel, to me, the troubling implication of Judge Wilson's question is that when you have an extraordinarily long conversion process like you have here, and then you have a sale of fixtures and rights, there's a long period where the most powerful aspects of the loft law protection don't apply because now there's been a sale and a subsequent tenant, and the ETPA provisions, which are supposed to be the ultimate goal of the conversion process, also don't apply. So you've got a kind of quasi-deregulated apartment as a beneficial to you side effect of not doing the conversion in a timely manner.
Well, I think that there are two different answers to that. The first one being, the legislature in enacting the rules and the loft board in enacting its rules provide for penalties for an owner who does not comply with the timetables for legalizing the unit and obtaining a certificate of occupancy. Those penalties are monetary. They're also involve denial of permits that you can get for the Department of Buildings.
Has this building been penalized?
I'm sorry?
Has the owner been penalized for not doing the conversion on time? Or-
Over the last, 30-something years, yes. I don't recall the last time. Monetarily. With respect to permits, they need to get loft board permission to to apply and get any permit to do construction in the building. Whether it be the ground floor retail or whether it be any of the units in the building, they need loft board permission for that permit. And the loft board, in its rules and regulations, provide that an owner who is not compliant with the timetables for legalizing the unit can have those permits denied. Plus, rents that may be collected by the other IMD or from the other IMD tenants in the building are not capable of being collected under the loft board's rules because you're outside the timetable for legalizing. Those are all the penalties that the loft board has and the legislator has put for someone who doesn't legalize in a timely fashion. And there are reasons why.
Counsel, if I can interrupt you, I'm on the screen. Hello, Happy New Year. Sorry.
Happy New Year.
Thank you. So, am I to understand from what you've just said that your view is in a free market economy that has these high rents, that those penalties outweigh what an owner might otherwise see as a cost-benefit analysis where those quote-unquote penalties, financial and otherwise, are outweighed by some other free market benefit that they're going to get by delaying decades the actions that they're supposed to take in a timely manner under the Act? Is that, I just want to make sure I'm understanding you correctly. Is that sort of the core of the argument? That no landlord would, I think some of the questioning is suggesting that whether it's just, some failure that has nothing to do with intentionality, there is otherwise potentially an incentivizing of the owner not to comply with the law and not to pursue what is the legislative goal here.
Well, I don't know that it's a cost-benefit analysis. There are a lot of reasons why a unit in a building ultimately doesn't obtain its certificate of occupancy in the timetable that the law provides. The conversion from a commercial to a residential building while the building is occupied by rent-regulated tenants is a cumbersome process.
40 years?
I can't speak to the particulars of what the problem was at this building.
You did remove the original tenants of the Lombardi, so you had a vacant apartment at that point, right? Before it was rented to Mr. Chen.
Yeah, but it's not apartment specific, right? Like, you have to get a certificate of occupancy permitting residential use for all the IMD units in the building. And though Lombardi vacated the unit and there was a period of vacancy, after Lombardi, the rest of the building still had to obtain the necessary items for conversion, like, and just examples like sprinkler systems, fire escapes, egress, bathroom fixtures, like there's a lot that goes into it, and it's collaborative with the tenants and with the loft board, all coming
So
to agreement
did you-
on
did
these
you-
terms,
did-
and if there is ultimately a
Did
dispute
your
among...
client ever ask for extensions based on good faith efforts?
I believe so, but not in the recent
Did they ever
years.
get any?
I'm sorry?
Did they ever receive any extensions?
The last one I think they got was many, many, many years ago.
Is any of that on the record?
No, no.
Okay.
Thank you, Counsel.
Let me ask you this, why should what you're talking about, let's assume for one moment the cumbersome process doesn't, it's not that the landlord is trying to game that system, or the owner, excuse me. Why is it that should fall on the other side of this equation? Why should the negative aspects of that fall on someone other than the owner? Why shouldn't you bear that burden? Because that would incentivize you to move this forward.
Well, there is a burden, but the burden is not perpetual rent regulation under two different rent schemes that conflict with each other. You know, whatever the penalties are, the loft board has them, and the owner will feel the burden of those penalties. But the penalty is not to cast a net of a second form of rent regulation onto the unit when it conflicts with the first form of rent regulation, the first form of rules that apply to this particular building. And that's the interpretation of the second department, you know, where the second department says, this is loft law, this is a loft law unit, there is no rent stabilization that comes on top of it.
Thank you, Counsel. Counsel?
Good afternoon, Your Honors. Ed Fajardo, Delato, and Fajardo. I am here for Respondent Raffaello Locatelli. May it please the Court. When we boil down the legal issues in this matter to their essence, we're debating what the ramifications were back in 1998 when the landlord purchased the fixtures from a prior tenant. At that point, the landlord was at a crossroads. The landlord had two legal avenues it could pursue.
Counsel, I'm sorry, understood, but let me just follow up on something Judge Wilson asked your colleague here. It seems to me, reading the civil court decision, that this is a 232A petition action, and the sole issue down there, at least the sole issue that seems to have been decided by the court, was whether or not you have some type of rent control protection that would prohibit this 232A action from going forward, right?
Absolutely.
So below, did you ever claim that outside of that rent protection status, that there was something else in the loft law that would prevent you from being evicted under a 232A?
Upon the purchase of the fixtures, the unit at that point, unless it was rented for commercial purposes.
No, could you just answer my question? In the proceeding below, did you claim any other protection other than the rent control provisions in response to the 232A action?
The rent stabilized provisions, Your
Right.
Honor, yes, absolutely.
What was it?
And the point is that this building is a building that predates 1974. There's no dispute, none whatsoever, that the apartment is capable of being legalized, and the landlord has failed to do that. So loft board, as we've already discussed, the goal of loft board is to transition to rent stabilization, not to escape it. However,
So what in the loft law are you pointing to outside the rent stabilization provisions, either under the loft board law, under loft law, or under the EPTA? What other provision would be a defense to the 232A action?
No, the rent stabilization provision, the
Okay.
rent stabilization code, the Emergency Tenants Protection Act are, at this juncture, what protects this particular tenant.
Understood. Thank you.
Yeah, absolutely. In other words, and I think, again, I'm going to go back to what the landlord did in 1998 and the predicament that the landlord put itself into. The landlord could have easily rented the apartment for commercial purposes, and there would be no issue. But instead of choosing that avenue, the landlord had a second legal avenue that they could take. They could have gone about legalizing the apartment, getting a certificate of occupancy, and renting it for residential purposes. The landlord chose neither of those two options. Instead, the landlord plowed ahead, went off-road, and just rented the apartment as a residential unit without bothering to ever legalize it.
Counsel, the landlord did what the landlord did, and now we're in a situation 40 years later where technically this is still an IMD building, and you're seeking the application of the ETPA, which seems to me to be kind of almost answered by Walensky. So could you tell me how you get around Walensky?
Sure, actually, I think what Walensky said was that if an apartment is incapable of being legalized, then rent stabilization will not apply. But Walensky itself, if you look at 2 New York 3rd on page 493, Walensky actually states such illegal conversions are not expressly exempted from the ETPA coverage. That language is already in Walensky. So Walensky, to me, is I am not here to,
Is this an illegal conversion?
well, it's not, yes, because
It's deleterious. You could use many adjectives, but is it really illegal?
it's illegal because the C of O does not provide for residential use at this juncture. And eventually, the landlord needs to get to the point where it has a legal certificate of occupancy for residential use, if that's what it intends to do with the building. So yes, in that regard, it's an illegal conversion. And Walensky says that that illegal conversion is not expressly exempted by the ETPA. What the second department has said is that there's situations where, whether it be for zoning, I guess presumably for zoning, that it is impossible to legalize a unit. Those are not the facts of this case. In fact, the landlord has said time and again, including in today's argument, that they still, even though it's taken 40 years, they're working towards legalization. So there's no issue that this apartment will eventually end up with a residential C of O. So in that
Let me see if I
regard,
can, I have a couple facts I want to see if I can straighten out. Mr. Locatelli was paying market rent up through 2016,
he was.
and was his tender of rent refused at the point of eviction?
It was. At the time that the landlord tendered a 30-day notice of termination, at that juncture, the landlord then rejected the tenant's tender of rent.
Okay, and Mr. Locatelli had filed a counterclaim for back rent, which he has abandoned essentially, right?
No, Judge. What was filed was a counterclaim for rent overcharge.
Right, sorry.
And that wasn't abandoned. It was not awarded.
Well, you didn't, right, and you didn't seek to appeal it, right? So that's not before.
We did. Leave was not granted.
Right.
Leave was not granted.
Right,
So
okay.
it wasn't abandoned, but that's law of the case. There's no rent
It's
overcharge.
not here. His claim for any sort of money is not here.
His claim for a rent overcharge is not before the court
So from your perspective, the claim that is here is, can he remain in the apartment or not?
as a rent stabilized tenant. Correct, Judge.
Well, rent stabilized or paying the rent he was paying?
Excuse me?
Well, he was paying a market rent of $42.50, right?
Right, so that rent will presumably have to be, at some point, the landlord has to go to DHCR and go about applying
And
for
that's-
whatever the valid rent would be.
And that's after legalization?
It could be, yes, it would be in conjunction with legalization, absolutely. You would legalize and then go to DHCR and then say to DHCR what the rent should be pursuant to DHCR's parameters.
Okay, got it.
Yeah. So again, I think Walensky is law. I'm not trying to circumvent Walensky in any way. I actually think it applies. I think if this court, and I don't presume to say that it's this court's job to necessarily find harmony if there is any discrepancy between the second and the first department, but again, I think what the second department has said doesn't apply to this case. The second department says you have, by the way, there's a case in the second department, the Berry case, where they said, and this is second department all the way up, not lower court, they said rent stabilization did apply. Because again, in that situation, the apartment was able to be legalized. It's only when an apartment cannot be legalized that then I think it would be appropriate for a landlord to say rent stabilization does not apply. Again, there's no one's going to dispute, I mean, you can't possibly have a legal fair market unit if you don't even have a certificate of occupancy for that unit. Makes no sense. There's no precedent that says that. And if this court were to somehow rule that way, it would be terrible precedent.
Thank you, counsel. Counsel?
So the loft law actually does provide that a unit may be used in violation of its certificate of occupancy if it is covered by the loft law. That's a specific proclamation in, I believe it's 2-10.
And if the owner is in compliance with the loft law?
Then they're permitted to collect rent.
No, as long as you're in compliance.
If you're in compliance, you are
So
permitted to collect rent, yes.
Is the building in compliance with the loft law now?
It is not.
So your view is you're not allowed to collect rent?
We are,
Legally?
I'm sorry?
Legally?
We're prohibited from collecting rent, correct.
Okay.
But that doesn't make him subject to rent regulation under the ETPA or rent stabilization. It's however long this proceeding takes, he is not going to pay rent. That's the ramification of not being into
So
compliance.
you don't really have a claim for money now either. It's really all about can he stay or must he go?
It is about can he stay or must he go, correct. The lower court found even if he does stay, even if he is covered, his rent is the market number that we discussed. But the question for this court is, does he stay or does he go? And how do you regulate these type of units citywide, statewide, right? When you have conflicts amongst the department, you know, the owners and tenants need a firm set of rules of what their requirements are. And I think we were talking about Walensky before. You know, Walensky actually was not an IMD, right? In Walensky, the court found that it was not qualified for the loft law, but they were deciding whether it was qualified for rent stabilization. And in Walensky, they said, it is not qualified for rent stabilization. It is an illegal unit, and if the legislature wanted to bestow rent stabilization on these illegal units, there would be no point for the loft law in the first instance. That's the holding of Walensky. But here, the First Department in this case is trying to take that even further and say, well, it's not one or the other. Now we should have both.
Counsel, if I can interrupt, why isn't your adversary correct in that interpretation that he advocates of Walensky, which is, yes, what you've articulated is correct, so long as there is no path to legalization. But if there is, then a party can pursue that. Why isn't he right about that?
Well, I think that that's a separate issue if the unit is not subject to loft law already, but since this unit is subject to loft law, it's kind of a non sequitur.
No, but even if it is subject to loft law, if indeed there is yet another path to legalization, why should the loft law be exclusive? Where does it say that the loft law is exclusive and supplants what might be another legal path when the ultimate goal of the legislature would be achieved through that other path?
The loft law actually does not provide that the ultimate goal is to usher every single unit into rent stabilization. The loft law actually provides to usher those units into stabilization where there is no buyout of rights and fixtures and improvements. The loft law provides where there is, those units do not get ushered into stabilization. So now you have a conflict where the loft law has specifically provided not to usher this particular unit into stabilization, but you have this other set of rules with the ETPA where they're trying to recapture it for stabilization. It's
That provision of the loft law, I think, says something a little different than what you said. And the way I read it, it says that if there's the buyout, then the rent regulation provisions of the loft law won't apply. But if there are other rent regulation provisions that would apply, the loft law doesn't purport to eliminate those. And one specific is buildings that have J51s.
J51s.
Right, would have other regulation of their rents. And the loft law doesn't disturb those even if there's a buyout. Do you disagree with that?
I disagree because I don't believe that they're referring to rent stabilization in that section. The loft board has promulgated numerous decisions that talk about it being the end-all of rent regulation, and those are cited in my brief. And it's the same way, like, you know, with rent
So how do you read that portion of the section that says, and I can read it to you, but it's in 7C,
No, I know it.
right, that says, if there is a buyout, the provisions of the rent regulation provisions of the loft law don't apply.
Correct.
But if there are other provisions that do apply, the loft law doesn't eliminate those.
I read it like you said it, Your Honor,
Well,
but that
what are
means
those
that the other section has to specifically apply.
What are
And-
those others? So, I mean, there is a portion of the EPTA, TPA that says pre-74 buildings more than 6 units, regulation applies.
Except as, and then there's a bunch of exceptions. And one of the exceptions are buildings that lack residential certificate of occupancy that are commercial in nature in 1974. There is another section that talks about units that are subject to buyouts under 286(6) and 12 are not subject to regulation. There's another section that says units that are subject to a substantial rehab after 1974 are not subject to regulation. And again, the DHCR has interpreted that conversion of a commercial building to a residential building after 1974 is a substantial rehab, deregulating the unit. So you have all of those exemptions within the rent stabilization that required that these loft units not get ushered in where they weren't meant to be ushered in the first instance. And again, the quote from Walensky is, had these buildings been subject to rent stabilization, what would be the point of the loft law? The loft law wouldn't be needed. The rent regulation under the loft law wouldn't be needed. And now, by trying to put them on top of each other, you run into problems where there are conflicts. And Acevedo doesn't talk about this. Acevedo only says, the word from Acevedo is may revert if otherwise qualified. But that was not, they were looking at cases when they were writing that decision that were not units that were already IMDs. They were looking at the decisions where you had units that, whether they should be subject to rent stabilization, aside from loft law. And the problem arises, like, this court heard yesterday in matter of Callan, where we were talking about pathways. When people believe that there are multiple pathways, then they choose what pathway they think is best for them, notwithstanding what the public policy is. The Loft Board was up here yesterday talking about how they believe that the only pathway for legalizing these units and for rent regulation of these units was the loft law. And they wouldn't agree to the removal of an application that was before them so that the parties can enter into this side agreement for the units to be covered under rent stabilization. And that's the problem that's going to keep coming up. They're both symptoms of the same disease, which is lack of clarity from the conflict between the departments here on what to do with these apartments after you have a sale pursuant to 286(6) and 12.
Thank you, counsel.
Thank you, Your Honor.
You're welcome.